Good day, Crime Talk aficionados. Well, you can tell we are not in the Crime Talk studios today. I am in Charlotte, North Carolina, because I have a court appearance tomorrow morning in, U.S. District Court. So we spent all day traveling, and we have a great show for you today. So let's get to it. First, is Nancy Grace in Mexico? And oh, by the way, TMZ got some more notes. I don't know about you, but I'm starting to think bogus. Next, the father of the Apalachee high school shooter faces murder charges. The jury heard opening statements and some of the first witnesses. Washington State University fires back in the bombshell filing, saying the sole responsibility lies with the convicted killer, Brian Koberger. And I agree. We've got this day in legal history. Today we have a legal maxim, not a quote, but a maxim. And our dumb criminal pulls a George Castanza, yada, yada, yada. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Now, before we get to today's docket, let me remind you to go to crimetalksearch.com, sign up for that background subscription service today. It could be the best few dollars that you actually spend ever. Go check somebody out that's coming into your life. All right, maybe they're not giving you that warm, fuzzy feeling. Maybe you think this is the one, the perfect one. Go check them out. If it's too good to be true, check them out. You're going to get information regarding phone numbers, social media presence, email addresses. You're going to find out if people have criminal histories and are they on one of those sex offender registries. Everything you want to know about somebody that maybe they're not going to volunteer when they're just, getting to know you. That's right. Go to crimetalksearch.com. You're going to be happy that you did. All right. Like I said, we are not in the studios today. We'll be traveling tomorrow as well. Got a court appearance. It's going to be a tough one. I was thinking about it, pondering it the whole time flying out here. Obviously, I prepared for it over the weekend. Tough cases, sometimes it's tough when you actually really like your client and they're a good guy and they've never been in trouble before a day in their life, but they hit it out of the park. It's something big. And it's, a white collar case. And it's just, I hate it. Anyway, enough about that. Let's get to today's docket. First on the docket, Nancy Guthrie's disappearance enters its third week. And now there's claims that she's in Mexico. That's right. So the investigation into the abduction of Nancy Guthrie, the 84-year-old mother of NBC Today's co-anchor Savannah Guthrie, has reached its now 16th day, ladies and gentlemen, with authorities intensifying efforts through forensic analysis and public appeals. Now, recent communications directed to the media outlet TMZ have introduced fresh speculation that the victim may have been transported across the U.S.-Mexico border, though law enforcement has yet to confirm these allegations. So what we do know is that Nancy Guthrie was reported missing from her residence in the Catalina foothills area near Tucson on February 1st, following an apparent home invasion captured on the doorbell ring cam. Now, the video shows a masked individual clad in gloves and dark clothing, tampering with the surveillance device. The ring, this is actually not a ring one, it's a Nest device, shortly after 9:45 p.m. on January 31st. Anyway, the Pima County Sheriff's Department, in coordination with the FBI, has classified the case as a kidnapping, with evidence including blood found at the scene and a glove recovered approximately 2 miles away from the property that appears to match the one worn by the suspect. Now, in the latest developments, TMZ received a fourth email on Monday from an anonymous individual claiming firsthand knowledge of Guthrie's whereabouts. Now, the sender allegedly observed her south of the border 5 days prior, accompanied by multiple individuals, and identified a main individual involved in the abduction. Now, the message, which demanded $50,000 in Bitcoin in exchange for further details, referenced prior warnings to shut up and suggested the perpetrator's international status, a phrase interpreted by TMZ founder Harvey Levin as a likely allusion to Mexico, less than 90 minutes south of Tucson. Now, this most recent letter to TMZ follows 3 prior emails to TMZ, including demands for $100,000. Now, the FBI reward and assertions of the kidnapper's international operations. Now, Levin has also publicly urged the center to provide verifiable proof, emphasizing the outlet's commitment to forwarding all materials to the police. Now, the Pima County Sheriff's Department and the FBI have acknowledged awareness of the notes, but have not validated their authenticity, describing them as unverified tips amid a broader influx of leads. Now, Savannah Guthrie and her siblings have issued multiple public appeals, most recently a video posted on social media on February 15th, in which Savannah stated, quote, "It has been 2 weeks since our mom was taken. We still have hope. It is never too late to do the right thing," end quote. Now, the family has offered a substantial reward, supplemented by the FBI's $100,000 tip incentive, I guess you'd call it, for information leading to her safe return. Then we got some forensic advancements that continue to drive the probe. The FBI is analyzing DNA extracted from the discarded glove, which has been entered into the National CODIS database. Now, preliminary results are expected within 24 hours, potentially yielding a breakthrough in identifying the perpetrator. Now, a person of interest was briefly detained near the Mexico border, but released without any charges. Now, to say that they found a glove that looks similar to the one that was being worn, that was in dark and not a great photograph, I'm saying, who knows? Apparently, they had searchers that were people that were with the police and people that volunteered early on that were discarding gloves as they walked through the desert. So I hope there's something there, but I'm not getting my hopes up. Maybe I'm just being a little hangry due to my travel schedule today, but I'm starting to get, a little frustrated by these tips that everybody turns in to be great. The reality of it is, let's face it, the police have no idea what's going on at this point. So now, as I have said before, all right, I've never kidnapped anybody, but I've represented several people who have. Okay. And the key thing, and if you look at basically past kidnappings throughout history, the people that do the kidnapping usually go directly to the source that they expect to pay money, and they usually want to keep the police out of it. They don't usually send, letters and emails and, whatever the mode of communication was at the time, to a third party, hoping it's going to get sent to the police because they don't trust the police. Of course, they shouldn't trust the police. They're going to arrest you because you have this information and potential knowledge as to the case. So as time goes on, and as I've said this almost, I don't know, a week and a half ago, I think zero chance that these notes have any credibility whatsoever. I know a lot of people may not like this, but some people say, well, why would a botched home invasion burglary, why would they want to take a little old lady? Ladies and gentlemen, I've represented criminals for 3 decades. They're not always the brightest. They're not always the quickest thinkers in moments of stress. They could have panicked. All right. I don't know. I hope Nancy Guthrie comes home safe, but each and every day that goes by, you know as well as I do, the odds of that go down. All right. Hate to be the spoiler alert here. Hate to be that bad guy. I'm just telling you the way it is. And I think hopefully something comes of it, but I'm not going to hold my breath. All right. Hope for the safe return, but let's get realistic. Day 16, and the police have really no more leads than they had on day 1. They've arrested, who's it, Jose or Carlos, the Uber driver. Then they arrested they detained the people in the Land Rover at the Culvers. They raided a house, and yet nothing. Why don't they just admit it? We really need the public's help, and we're going to offer a lot of money, because the threat of imminent incarceration tends to break the bonds of loyalty. But a good reward, well, let's just say that speeds up the break of loyalty. Let's just get real. We'll bring you the latest when it happens, ladies and gentlemen. I hope I'm wrong on this one. I hope I'm wrong. Next, a historic case opens in Georgia. The father of the Apalachee high school shooter faces murder charges, and we got opening statements today. So the trial of Colin Gray, the father of the teenager accused in the deadly 2024 Apalachee high school mass shooting, began today with an emotional opening statement and the first witness taking the stand in a case that is testing the boundaries of parental criminal responsibility. Remember, I told you this was coming, ladies and gentlemen, when they start doing novel and unique theories to say that the parent is responsible for the child. I I told you it was going to open up a floodgate, and here it is. I understand people want accountability, but unless the parents say, "Son, it's time to head on out to go do that mass shooting," they shouldn't be criminally responsible. Okay, if being a bad parent is going to involve criminal responsibility, ladies and gentlemen, we all might as well just put our hands up now and say, "Put the cuffs on me." Okay, being a parent is doing the best you can with what you got sometimes. All right. Anyway, so Gray, who's 54 years old, has pled not guilty to the 29 felony counts, including 2 counts of second-degree murder, 2 counts of involuntary manslaughter, and multiple counts of second-degree cruelty to children. Prosecutors allege that he gave his then 14-year-old son, Colt Gray, access to an AR-15 style Sig Sauer M400 rifle purchased as a Christmas gift in December of 2023, despite warnings that the boy posed a danger to himself and others. The shooting occurred on September 4th, 2024, at the Apalachee High School in Winder, where police say Colt killed 2 students and 2 teachers and wounded 9 others before surrendering. The prosecution says this case is about the defendant's actions. In his opening statements, the Barrow County District Attorney Brad Smith told jurors that this is not a case about holding parents accountable for what their children do, Smith said. This case is about the defendant and his actions in allowing a child that he has custody over access to firearms and ammunition after being warned that the child was going to harm others. Smith laid out a timeline of warning signs dating back more than a year. And in 2023, law enforcement questioned Colin and Cole Gray about online threats linked to a potential school shooting. Despite that, Gray bought the rifle and allowed his son to keep it in his bedroom. Prosecutors pointed to texts Colt sent his father shortly before the shooting. "Whenever something happens, just know the blood is on your hands." They also highlighted Colt's reported fascination with school shooters and behavioral issues, including a text in which he mentioned hearing voices telling him what to do. The defense, the plan was hidden. Defense attorney Brian Hobbs countered that Colin Gray was an engaged father who sought mental health for his son and cooperated with police. He argued Colt deliberately concealed his plans from everyone, including his father, who has even scheduled a mental health appointment for the day after the shooting. You cannot hold someone criminally responsible for failing to predict what intentionally was hidden from them, the attorney said. And the shooting's planning and timing were hidden by Colt Gray from his father. Remember the Columbine shooting? Harris and Klebold, right? The parents said, "We didn't know it was hidden from us. It was in their basement. They were planning, they were building bombs in their basement," ladies and gentlemen. No charges because people knew the children were the ones responsible. Anyway, after opening statements, the prosecutors called their first witness from the Barrow County school system, as well as the sheriff's office. Computer science teacher Suzanne Harris testified that on the morning of the shooting, Colt's first full week at the school, she noticed an odd poster-like object wrapped in clothing protruding from his backpack. The bag appeared unusually heavy. Colt struggled to carry it, and he seemed nervous. He asked if the school had an active shooter drill scheduled and gave minimal answers when she inquired about the project. Harris emailed a counselor about her concerns and later felt a chill when she realized the object may have been the concealed rifle. She kept her class locked down once the alert sounded. Then we heard from Lieutenant Barry Chandler of the Barrow County Sheriff's Office describe the school's emergency alert system, which had been connected to 911 just months before the attack, allowing rapid notifications to law enforcement. Then Deputy Superintendent Matt Thomas walked jurors through surveillance video excerpts from a school bus and inside the building, showing Colt carrying the backpack and the large poster board sticking out, which prosecutors say he used to hide the rifle. Additional footage is expected later in the trial, which is projected to last about 3 weeks. Obviously, we'll be bringing it to you live here on Crime Talk, ladies and gentlemen, so check it out. It's going to be an interesting case, all right? So what's the core legal issue here? Well, at the heart of the case is a question that has gained, obviously, national attention in wake of multiple shootings. Under what circumstances can a parent be held criminally liable for harm caused by their minor child? right? Now we know if you're a cop and you fail to go in, the jury's going to say, hey, you're just being a cop, you're doing your best. That we saw in Texas just a few weeks ago with the school police officer being found not guilty of all counts. Anyway, in other words, the charges focus on Gray's own conduct, consciously disregarding a substantial and unjustifiable risk by arming a child he allegedly knew was troubled, rather than vicariously punishing him simply because he is the father. Now, the defense contends there was no way Gray could have foreseen the specific attacks because Colt hid his intentions so effectively. I mean, he was able to hide it from his teachers, who was on hypersensitivity alert, and the father didn't know. That's the defense. If convicted, Gray faces up to 30 years per murder charge times 4. That's 120 life sentence. Anyway, jury selection for the trial was completed earlier with a panel drawn from Hall County due to pretrial publicity concerns in Barrow County. Like I said, the proceedings are being held in the Barrow County Courthouse with strict rules limiting media coverage inside the courtroom. Now, as testimony continues in the coming days, the case is expected to delve deeper into Gray's family history, mental health records, and exact circumstances surrounding the rifle's purchase and storage, which obviously could decide whether a father can be held criminally responsible when his child pulls the trigger. Next, Washington State University issues a bombshell. Yeah, the sole responsibility lies with convicted killer Brian Kohberger. In a scathing 51-page legal response filed this week, the Washington State University has categorically rejected claims that it bears any responsibility for the 2022 murders of the 4 University of Idaho students, insisting the horrific crimes were committed solely by former WSU graduate student Brian Kohberger. Now, the university forcefully denies, and it comes just weeks after the family of Kaylee Gonzalez, Madison Mogan, Zana Kernodle, and Ethan Chapin filed a high-profile civil lawsuit accusing WSU of negligence, Title IX violations, and deliberate indifference for allegedly ignoring more than a dozen formal complaints about Kohberger's predatory and threatening behavior towards women on campus. Okay, let's say that's the case. What does that have to do with him going to kill 4 people? This is what I'm talking about, ladies and gentlemen. At a certain point, you can't just blame everybody for a particular individual's wrongdoing. At when point does it stop? One could say, I mean, just if you want to take it, it takes a village, all that kind of stuff, right? Where were his neighbors? Let's sue the neighbors. Heck, let's sue the parents, right? Let's sue his parents. They should have known that he was not right mentally over the years for everything that he's been through, right? When does it stop, ladies and gentlemen? Listen, I'm an attorney, but the world needs less litigation. The world is too litigious, all right? Hold somebody responsible if they're actually the ones that did it. I get it. You're not going to get any money out of Brian Kohberger because at the end of the day, it's always about the money, ladies and gentlemen. Anyway, WSU denies that it is in any way responsible or liable for the murders. Now, the filing states quite bluntly. Now, attorneys for the university argue the killings were the actions of Brian Kohberger alone and were not foreseeable based upon what the school knew at the time. They further contend that the university has no legal obligation to prevent the crimes and acted in good faith throughout the whole process. Now, this lawsuit was filed back in January of this year in the Washington State Court. The families allege that WSU received at least 13 formal reports of Kohberger, the then PhD student in criminology, and paid teaching assistant living on campus housing, engaging in stalking, harassment, and menacing conduct. And instead of acting decisively, the suit claims the university continues to support him with a salary, health insurance, housing, and access to university resources, effectively enabling the November 13th of 2022 stabbing deaths in Idaho. In its response, WSU admits only the most basic facts, that it admitted Kohberger into its criminal justice PhD program and provided him standard student employee benefits. On virtually every other allegation, including claims that the officials knew of his behavior and failed to protect the community, the university responded with a near blanket denial. WSU is without knowledge and information sufficient to admit or deny these allegations and therefore denies the same. That is standard boilerplate language in any civil case, ladies and gentlemen. Anyway, a lot of people are saying, and I agree, WSU's intent is to fight the claims vigorously rather than settle, setting the stage of what become a lengthy and legally and emotionally charged court battle. We'll see what happens. Usually they'll settle at some point. It depends on, frankly, what the insurance company is willing to pay. Now, the families haven't yet responded to the new filings, but described the lawsuit as an effort to hold the university accountable for what they call a preventable tragedy. Heck, why not sue the Moscow Police Department? Why not the neighbors? They should have seen something suspicious. You could go on, ladies and gentlemen. My heart goes out to the family. I could not imagine losing a child. I really could not. But sometimes bad people, there are evil people in the world, do things to good people. And you're never going to be able to explain it. You're never going to get the people back. And suing somebody just trying to make a statement is not the way. I'd be curious to see if these attorneys for the Idaho 4 families are taking this on a contingency fee basis. More than likely they are. I think they are going to lose their shirt on this one. But hey, I guess we'll find out in a couple of years if I was correct or not. Next on the docket, this day in legal history. February 16th, 1833, ladies and gentlemen, Barron v. Mayor and City of Baltimore. In a unanimous United States Supreme Court decision written by then Chief Justice John Marshall, the court held that the Bill of Rights, specifically the Fifth Amendment's taking clause, applies only to the federal government and does not restrict state or local governments. Remember, ladies and gentlemen, a lot of these, the Bill of Rights applied to the federal government, but the state, up until this point, until even including this point, said, no, Bill of Rights don't apply to states. Now, obviously, that's changed over the years with the adoption of the 14th Amendment Due Process Clause, later enabled what they refer to as the incorporation of most Bill of Rights protections against the states. But it just shows you at this one time, those Bill of Rights only applied by the federal government. Thank goodness that was changed. February 16th, 1837, the United States Supreme Court, in a 6-1 opinion, upheld a New York state law requiring ship captains to report passenger details and post bonds for immigrants likely to become public charges, basically public assistance, right? Or criminals. Anyway, the court ruled that this was a valid exercise of the state's police powers to protect public health and welfare, not an unconstitutional interference with Congress's exclusive power over interstate commerce. This early case delineated boundaries between federal commerce authority and state regulatory power over immigration and local matters. We brought this up because it just shows you how things change over time, ladies and gentlemen. Next date, February 16th, 1945, signing of the Alaska Equal Rights Act, the first anti-discrimination law in the United States. The Alaska Territorial Governor, Ernest Gruning, signed the Anti-Discrimination Act into law, the first statute of its kind in the United States, prohibiting racial discrimination in public accommodations, employment, and other areas. It passed after a powerful speech by the civil rights activist Elizabeth Perovich before the territorial legislature, directly countering opposition and highlighting everyday discrimination against Alaska Natives. The law predated the Federal Civil Rights Act of 1964 by nearly 2 decades. And probably a better thing, right? Discrimination is bad. Content of your character, quality of your person, all that good stuff. Next, one of the most foundational legal quotes, I guess you could say, it's actually a legal maxim today. Pacta sunt servanda. Agreements must be kept. That's right. In the broader, concise legal principle in contracts law, which there's contracts in criminal law, it's called plea agreements. It means that once parties freely enter into a valid agreement or treaty, they are bound to honor it in good faith. Essentially, your word or your promise creates a binding obligation. Throw that out there, ladies and gentlemen. There's so many people out there that simply just don't keep their word. It's one of my pet peeves in life. You say you're going to do something, you get it, you do it. And if you can't, you better have a darn good reason, a plan to explain why we're not doing it. Your word matters. That's all we have. Just as we talked about, if you missed it with our guest we had the other night, your word matters, your reputation matters. Next, our dumb criminal of the day pulls a full Castanza. That's right, George Castanza, that is. In a move that would make even George Castanza himself mutter, "This is the worst idea I've ever had." A 30-year-old transient told police his name was George Castanza, then looked shocked when the ruse lasted roughly 4 seconds. So police were out patrolling the bustling fishing pier and entertainment area Tuesday and spotted a man who matched the description of Josiah Darling, who had an active arrest warrant out of a neighboring county for skipping a January court date for a trespassing charge. Now, Darling, no stranger to law enforcement, apparently decided the best defense was a good offense, specifically the offense of pretending to be a fictional, short, stocky, bald New Yorker with a pathological fear of commitment and an encyclopedic knowledge of nothing. When Officer Matthew Capone politely asked for his name, the suspect didn't hesitate. "George Castanza," he replied, according to the arrest report, delivering the line with the casual confidence of a man who once tried to pass off a velvet painting of dogs playing poker as fine art. Pro tip for future Florida man impersonators: if you're going to steal a Steinfeld identity, maybe reach for the deep cuts. Perhaps Kenny Bonilla, the worst comedian ever, or David Putty, the face painting hockey fan. At least require the cops to Google something. George Costanza is like showing up to a bank robbery in a neon sign that reads, "I'm the guy you're looking for." Undeterred by the sitcom level chutzpah, officers ran facial recognition software and, shocker, confirmed the man was, in fact, Josiah Darling, not the unemployed sponge cake enthusiast from Queens. He was promptly arrested on the original trespass warrant, plus a shiny new charge of resisting an officer without violence, also known in legal circles as "I'm not lying if I believe it's felony." Darling was booked into the Pinellas County jail, where one assumes he spent the night staring at the ceiling, quietly whispering, "Serenity now, serenity now." On Wednesday morning of last week, Darling appeared in court and pled no contest to the misdemeanor resisting charge. He was ordered to pay roughly $550 in fines and court costs, a sum that coincidentally could have bought him a decent fake mustache and a better alias next time. His defense never officially offered, but we all know that what it would have been. It's not a lie if you believe it. Anyway, the judge, sadly, was not a Seinfeld fan. Case closed. Yada, yada, yada. We'll see you in court, George. All right, ladies and gentlemen, that's all we have for you today. Thanks for joining us. We'll see you next time. And remember, the Constitution matters.